On the opposite side of recruitment and selection are employment separations. Much consideration is given to the onboarding and retention phases of the employee and employer relationship, leaving the separation phase to oftentimes be given far less attention. Employee separations, which can also be known as offboarding, describes the separation process when an employee leaves a company. An employee separation could occur for various reasons, including the employee resigning, a retirement, the death of an employee, or possibly the involuntary termination of the employee. There are unique risks of offboarding, such as protecting company trade secrets, a potential damaged reputation, lost time, and potential legal defense costs, among others. It's often valuable to conduct an exit interview with the departing employee to use information gained to assess what should be improved, changed, or remain intact. Key questions to be asked may be, what are your main reasons for leaving? Or what could the organization do better to keep employees like you? A reduction in force, also known as a RIF, occurs when a position is eliminated with no intention of replacing it. This results in a permanent decrease in headcount. An employer may decide to reduce its workforce by terminating employees or by means of attrition. In a reduction of force, the first step is to select employees for layoff. The selection criteria should be designed to identify the employee traits that will be instrumental in meeting the company's goals. The next step is to avoid adverse action or disparate impact. Adverse action impact refers to employment practices that appear neutral but have a discriminatory effect on a protected group. Adverse impact can occur when identical standards or procedures are applied to everyone, despite the fact that they may lead to a substantial difference in employment outcomes for the members of a particular group. An adverse impact analysis provides a statistical review of the employment decision to determine whether discrimination is indicated in the decisions, even if unintentionally. If your employment process reveals evidence of adverse impact, it is important that you are able to justify your personnel process and decisions. When reviewing impacted employees for adverse impact, we will commonly use the 80% rule. This rule, also known as the 4/5 rule, states that the selection rate of the protected group should be at least 80% of the selection rate of the non-protected group. For example, let's say for a job opening we had 100 applicants. 55 are non-minority and 45 are minority applicants. And of those, 60 are male and 40 are female. Of the 55 non-minority applicants, 6 were hired, giving us an 11% selection rate. Of the 45 minority applicants, 2 were hired, which gives us a 4% selection rate. We would then calculate the impact ratio by dividing the selection rate of the minority applicants, which was 4%, by the selection rate of the non-minority applicants, which was 11%. This will give us an impact ratio of 36%. And since 36% is less than 80%, we do have adverse impact, as the 80% rule states that the selection rate of the protected group should be at least 80% of the selection rate of the non-protected group. As we further look at our breakdown between female and male applicants, we can do similar calculations. 8.3% of males were hired and 7.5% of females were hired. By dividing the higher rate of females by the higher rate of males, our impact is 90%. Since 90% is above 80% of the selection rate of the non-protected group, in this case, we do not have adverse impact. Employers must also determine if the Worker Adjustment and Retraining Notification Act, also known as the WARN Act, will apply. The WARN Act requires employers conducting a large-scale layoff to provide 60 days notice to affected employees, with few exceptions applying. Employers must inform affected employees if the layoff is permanent or temporary, and if the latter, what the expected duration is. Employees must be notified of their expected separation date and if there are any bumping rights. employers should clearly outline the process for recall rights and applying for future positions with the company if available. In addition, a number of states have enacted their own version of such legislation, which extends the notice requirements to smaller businesses conducting layoffs. Reviewing state laws will be important, given that many WARN Acts often impose additional requirements that differ from federal law. There are few exceptions when a WARN Act may not be required. The unforeseeable business circumstances exception may apply when a plant closure or mass layoff is caused by business circumstances that were not reasonably foreseeable. The U.S. Department of Labor guidance provide examples of circumstances that constitute unforeseeable business circumstances, including sudden, dramatic, and unexpected actions or conditions outside the employer's control, such as the government-ordered closing of an employment site without prior notice. If this exception applies, it may permit an employer to give less than the full 60-day notice. Under the natural disaster exception, no notice is required. This covers items such as floods, earthquakes, hurricanes, droughts, storms, tidal waves, or tsunamis, and other similar effects of nature. These are considered under the natural disaster provision. To qualify for this exception, an employer must be able to demonstrate that its closing or mass layoff is a direct result of the natural disaster. The faltering company exception applies to a complete plant shutdown, not a mass layoff. Under this exception, an employer must reasonably and in good faith believe that providing the 60-day notice to its employees would have jeopardized its ability to secure the needed capital or allow the business to remain open. In 1990, Congress amended the Age Discrimination in Employment Act, also known as ADEA, adding the Older Workers Benefit Protection Act, also known as the OWBPA. The OWBPA requires employers to offer older workers, which is defined as those who are at least 40 years old, benefits that are equal to, or in some cases, cost the employer as much as the benefit it offers to younger workers. The goal of the Act is to ensure that older and vulnerable workers aren't unfairly laid off from work and don't experience discrimination based upon their age. If it is determined that a release from age discrimination will be necessary in exchange for severance pay, then the severance package must comply with the OWBPA to effectively release claims under the Age Discrimination in Employment Act. Under the OWBPA, employers also need to provide workers who are age 40 and older with a consideration period of at least 21 days whenever at least one older worker is being separated, and at least 45 days when 2 or more older workers are being separated. Additionally, employees must receive a revocation period of at least 7 days. Such a release will have a few requirements, such as the release must be in writing. It should be written in a manner that the employee would understand. It must be in plain, clear language that avoids technical jargon and long, complex sentences. It must not mislead or misinform the employee executing the release. It must not exaggerate the benefits the employee is to receive in exchange for signing the release or the limitations imposed on the employee as a result of signing the release. It must specifically refer to the Age Discrimination in Employment Act. It must precisely advise the employee to consult an attorney before signing the release. Also, it must not require the employee to waive rights or claims arising after the date the employee signs the release. Severance packages may include salary continuation, vacation pay, continued employer-paid benefits, or employer-paid continuation of health coverage, also known as COBRA premiums. Additional services may also be offered, such as outplacement assistant, counseling, job search workshops, and other similar services. The final step is to conduct the layoff session and inform the workforce of the layoff. Last but not least, we must prepare what we will say. It's best to be ready to talk about why the decision to lay off the employee was made and prepare a script to help ensure we cover all the details we need to go over with the affected employee in a clear, professional, and empathetic manner. The goal of the notification meeting is to deliver the news with empathy and in a manner that allows the employee to retain their dignity.